don't know how powerful your voice is. They don't want to hear another legislator. They don't want to hear somebody else that's advocated. Sometimes they just want to hear that personal story.
Prevention is done with regard to asbestos by stopping all use.
Very tiny doses of asbestos can cause malignant mesothelioma.
The only way to stop asbestos-related cancers is to ban it.
About 70 other countries have asbestos bans. The U.S. still doesn't.
This isn't right. Don't let this happen to other families. It can be prevented.
About 40,000 Americans die every year of asbestos-caused diseases.
The fourth session, which is all about the law. The title is Navigating Asbestos Law, and we're going to look at various aspects of the law from UK work with Harminder's excellent accomplishments and her commitment to asbestos victims. Eric Olson, who used to work for Senator Boxer, and I think you should add to your, you should all add to your intros, your abouts, but Eric and I worked together for almost 20 years before the senator, however long that was, before she retired. Bob Sussman, full disclosure, is ADAO's counsel, and he works basically pro bono, very hard, and he sued the EPA 3 times and won. He's very dedicated to the cause. And of course, Barry, I'm going to get you Castleman, is one of the smartest experts I know, who I first met at a train station, and you gave me your legal and medical aspects book, and it was about this thick. And I thought, who is this guy? And I started to read his book, and then I soon learned who you were, Barry, and I have the greatest respect. So let's formally get started. Harminder, please come to the podium and start your personal session.
Right, so my name is Harminder Baines. I'm a lawyer, and I'm a partner at Lee Day Law Firm, which is based in the UK. And sadly, I know too much about this disease because my father, Harry Singh Baines, died from mesothelioma 24 years ago. Right, so I've listened to everyone today, and I agree. I've been dealing with legal cases for just under 30 years, and to be honest, I'm angry that year after year, we still have to have conferences like this. We shouldn't be having to come here. You know, this matter should be settled. We know asbestos is dangerous. No amount of asbestos is safe. You know, so lawyers like me and lawyers in this room, we win legal battles. But the war against the asbestos industry is still alive and kicking, have no doubt about that. And the reason it's alive and kicking is because it's worth millions, billions of pounds of money to the asbestos industry. It's as simple as that. And the asbestos industry just doesn't want to listen to the science, and it does it deliberately because it's worth so much money to them. They're sending doubt scientists. They're sending doubt scientists deliberately. Last year, I spoke to you about what had happened to Dr. Robin Rudd, a renowned doctor in the UK. You know, someone called John Bridle, who refers to himself as a professor, and he's not a professor. He basically tried to get Robin Rudd struck off the medical register in the UK for simply advocating that Cristal was dangerous and it caused mesothelioma. I also spoke last year about your very own Jacqueline Moline, about what the industry is trying to do to her in court in the US regarding her opinion that talc contains asbestos and is causing mesothelioma. And the same industry is basically tying Linda Reinstein into knots by subpoenaing her. And they simply do that because they do not want her to have time to spend on her campaigning work. The asbestos industry sends in spies. We all know about this man, Rob Moore, who attended ADAO conference on 2 occasions. I mean, look at him. He looks like any one of us. So you should have no doubt, people in this room or next generation, this war is going to continue. These spies are still out there. Now, if you may remember, the spy was actually hired by a company called K2 Integrity. If you go on their website, it actually says, our investigations team helps clients gain control of risks that may threaten the value they have worked hard to build. mean, that's what it says on their website. But if you look on the other side, that's what I think it should say. It should simply say, perhaps it should say, we have experience of sending in spies like Rob Moore to lie and deceive campaigners, doctors and lawyers. Our spies will record conversations using hidden microphones in their clothes. Our spies will take money from campaigners and lawyers. You know, Rob Moore took £3,500 from me because I wanted to help him set up a charity, and the $3,500 was to go towards the legal fees. Linda Reinstein gave him money. So K2 integrity. In travel. So K2 integrity. I mean, this is what it should say. So I hope you agree, and hope K2 integrity. Can you please, if you're listening, watching, change your website. If you don't know about Rob Moore and his story, a podcast came out last year from a renowned UK journalists, Kerry Thomas and Alexi Mustras. You can find it on Spotify. It's called Into the Dirt, and it is well worth a listen. And I think, you know, people, youngsters, I think someone said here, the next generation need to be aware of what's going on. You really do need to listen to these things. And this is a way of getting the message out. You know, use podcasts, use the media. There is also a film coming out, and this is hot news or up-to-date news. It's coming out in April 2025, and it's called Corporate Spy. And it's by a Norwegian company called Indie Film. So would you please all look out for that? I think it's going to preview later on this year in Scandinavia. So that'll be interesting. I think some people in this room actually took part in that film. The other thing I want to talk to you about today is a company called CAPE. Now, I think some of you are aware about the legal case which I did against CAPE in the UK about 3 or 4 years ago now, where I managed to get, on behalf of the Asbestos Victims Forum, some documents which they wanted kept hidden, because these documents showed exactly how dangerous their asbestos products really were. And they deliberately misled the government. They deliberately misled external scientists. Their own in-house scientists, for example, said Asbestolux was safe, but they knew that it absolutely was not safe and that it was very dangerous simply by handling it, simply by carrying Asbestolux, which is known as ABI board, which is in schools, hospitals, buildings, public buildings, homes. Simply by handling it, the asbestos fibres are released. So this company is important to you just as much as it is in the UK. The reason being, ever since I did that case and the documents which have been now placed in the public domain, I have had lawyers contact me from over the world, and they wanted information about it. And that's because there is a law firm also in the US which is currently suing CAPE. And that's because CAPE is trying to escape from legal financial responsibility, i.e. paying victims compensation in South Carolina at the moment. So people dying from asbestos diseases, CAPE is trying to avoid it by not taking part in the case. And this is a statement which is Morgan, Lewis and Bockless LLP. I can read this out because it's a statement from them. They said, there is a legal case against CAPE affiliates going on currently in South Carolina. The court appointed a receiver to handle CAPE's affairs there because CAPE, as it always does, refused to appear in the United States court case. The court's receiver is seeking judicial determinations regarding CAPE and other companies to ensure US plaintiffs dying from asbestos diseases can pursue compensation from them. Mohed Altrad, who is the president, is refusing to acknowledge the South Carolina's court's jurisdiction and is refusing to participate in the litigation altogether. The CAPE/Altrad lawyers have tried a large number of series of appeals and are unsuccessful, have tried to remove it from the federal court and have even threatened litigation against the South Carolina receiver in the High Court of England and Wales to get the legal case struck out. Despite the best efforts to avoid it, the case is scheduled to go to trial in South Carolina in December of this year. So this is why CAPE is actually you guys in the US should also know about this company. It's not just a UK problem. Alltrad is the parent company of CAPE. So this is a legal case which, on behalf of the asbestos victims support groups, we succeeded in the Supreme Court of England, which allowed the documents to be put in the public domain, which is now, as I say, helping various victims all over the world. Now, what do those documents show? Well, as I said, these are the sorts of things they showed. You can read what they said. But I also think you all must have heard of an American company called Johns Manville. So CAPE encouraged Johns Manville to not put warning labels on Asbestolux. And, so they actually knew how dangerous it was, yet they actually encouraged other companies to deliberately not put warnings on simply for profit. They had their own in-house scientist called Dr. Smiver. He accepted that mesothelioma could be caused by small and possibly small amount of asbestos exposure. And that he actually says in these documents, no type of asbestos is innocent. But that is not what they were openly telling the public. So this all came out in the documents which were kept between themselves. This is why they wanted these documents to not come out in the public domain, because they actually tell the real story. So the Asbestos Victims Forum in the UK, who was my client, which is a charity which represents victims of asbestos, the support groups all over the UK, have said to CAPE/Alltrad, we won this case. Would you please now pay £10 million for medical research to Asthma Lung UK so that they can actually try and find a cure for mesothelioma? That's what they're asking for. They're not asking for the £10 million to be paid to them. They want it paid to Asthma Lung UK. Alltrad, CAPE, have to date not responded. We had a meeting with Ranoran. They've not given the 10 million at all. But they are, they're trying to whitewash their image because they do have enough money to support the French and New Zealand rugby teams. Look at them. This is their rugby teams wearing their T-shirts, Alltrad. So they're trying to whitewash their image. We should not let them get away with this. 10 million to a company like CAPE and Alltrad is peanuts. They've got billions. And this is a photograph of Mohamed Alltrad. He's actually been convicted in the French courts of bribery and misuse of corporate assets. And there's Ranoran, and he is giving instructions. He's a lawyer. He's given instructions. Not only did he give instructions to fight the legal case in England, which I was doing on behalf of the Asbestos Victims Forum, but he's also given instructions to the case I've just mentioned in the US South Carolina court. So I think you should all be aware of who these people are. So the unbelievable thing is, this company called CAPE, which is also, as I've explained, in the US, what it did in the UK was, and as I said, it's also done in the US, it imported asbestos into the UK. It then spent years manufacturing asbestos products like Asbestolux. Then it also put it into the buildings in the UK. And now, unbelievably, it's applying to the government to win contracts so they can remove it from the UK buildings. And and the UK government has recently awarded them a £3.5 billion contract to remove it from buildings. So isn't that outrageous? This company is going full circle. It's continuing to make money out of something which they knew was fatal and kills people. The last thing I want to speak about is Hannah Fletcher. So Hannah Fletcher is a client of mine. On the left, you can see that's how she was pre-mesothelioma symptoms. On the right is how she is today. She was exposed to asbestos by talcum powder and by wearing makeup which contains asbestos. She was so brave and she instructed me, and she brought a case in the US New York County Court, and she basically was successful in obtaining compensation against several cosmetic companies. Now, for legal reasons, I can't mention the names of those companies, but there is a judgment on the website, 2019, which is on the website should you wish to read it. And she is the first person in the UK who managed to convince a US court that they had jurisdiction to hear a victim who was dying and living in the UK, that her court case can be brought in the US. So that's her. And if you want to hear her story, I think some of you also were involved in this. This is a BBC podcast. It's called How They Made Us Down to Everything, and it's called Talc Tales, and it's about asbestos in makeup. Yes, so on behalf of the Asbestos Victims Forum, I hope you are aware now that CAPE is also based in the US, and how it's not just a UK problem. The Asbestos Victims Forum has asked people to sign a letter, which they are, and I think we need to work together. So they're asking you to sign the letter if you would, which can be sent to RANORAN and CAPE, to ask them if they will please pay £10 million for medical research to asthma lung. And then also, perhaps we can take a photograph outside later after the conference. Thank you very much. Bye-bye.
Eric Olson, who is not only a wonderful human, but he's a brilliant environmental lawyer. He used to do policy work for Senator Boxer. He's now, is it Senior Counsel for Health? You should, yes, but he's brilliant at NRDC, and he's taking his weekend to come here and talk to us. Eric?
Well, thanks very much. It's an honor to be here and to have worked with Linda for 20-something years. I'm going to talk about some of the history of legislation that's passed and not passed, and why it's so challenging to actually address asbestos in so many different products. So my conclusion, I'm not going to hide the ball, is that we still need an asbestos ban. There are about, as you've heard, 40,000 Americans that die every year from preventable asbestos diseases, and about 70 other countries have asbestos bans. The US still doesn't have one. We did have, it wasn't a complete ban, but EPA did issue a ban in 1989 under the Toxic Substances Control Act. Industry sued in a court of appeals that they expected would go with them, and got the asbestos ban overturned in 1991. And the impact of that was not just on asbestos, but on pretty much everything under that law. It completely upended how that law was implemented and basically gutted the law until it was amended. And I know that Bob Sussman is going to talk more about that 2016 statute. The court's decision basically shut down EPA. So there were a lot of proposals, but I'm not going to go through all of them, but Patty Murray, senator from Washington, Henry Waxman, one of my heroes, Steve Cohen, all had the Ban Asbestos in America Act. It was proposed multiple times from 2002 through 2007. The Bruce Vento Ban Asbestos Act also was proposed by Gene Green and Betty McCollum. None of those actually moved. Then in 2017, Linda and I worked on this. We got a Ban Asbestos in America Act passed through our committee, the Senate Environment and Public Works Committee. It then passed the full Senate, but there was a tweak made in it by some Republicans that successfully really weakened it substantially. It went over to the House, and it was never passed through the House. So unfortunately, that's the last time we really saw significant movement on an asbestos ban in the United States 17 years ago. Obviously, I'm not going to go through the details of what the RBAN Act, the Alan Reinstein Ban Asbestos Now Act says. It's been reintroduced multiple times since 2016, every Congress for the last 4 Congresses. It was actually approved in committee, in the House Energy and Commerce Committee, by an overwhelming vote of 47-1 back in 2019, but it never got a floor vote. And again, it's been reintroduced. It was reintroduced last year by Senator Merkley and Representative Bonamici, and we'll see. I don't think there's time to enact it this year, so we'll be back at the up to bat again next year. The Asbestos Hazard Emergency Response Act was a significant law. I think we heard a little bit about that this morning. What has passed? That was the most significant first one that passed in 1986. You heard a little bit about it. I'm not going to go into the details, but it does require local school agencies to address asbestos and prepare management plans, and also EPA issued a model plan, which wasn't great, but the major issues have been enforcement, among other things. The Asbestos Information Act passed in '88. It provided some transparency, but didn't fully require full disclosure of imports and manufacturing. Then there was a SHARA back in 1990 that extended funding for the school asbestos abatement program, and it also increased the number of training hours that were required for asbestos model accreditation plans, and also EPA expanded the accreditation requirements to cover asbestos abatement projects in all public and commercial buildings and schools. In theory, again, there have been real enforcement issues with that. The Clean Air Act, this is an important one, and talk about not being enforced. So there's a national emission standard for hazardous air pollutants for asbestos. This was updated in 1990, and theoretically, there are work practices for asbestos control during demolition. I will tell you, half a block from my house, there is a large commercial building that's being demolished, and they're just like barely spraying a little bit of water on it, and you can just see the dust wafting up. I'm sure that they have not complied with a lot of these requirements. This is typical. Asbestos-containing waste, in theory, must be sealed and disposed of in a qualified landfill. The building owner and operator is supposed to notify the state before demolition or renovations if there's a certain amount of asbestos in the building. And some manufacturing and fabrication is not supposed to emit visible emissions to the outside air, and they're supposed to follow certain air cleaning procedures and requirements for the waste. Safe Drinking Water Act, which is something I've spent a lot of time on, EPA did adopt a very weak asbestos and tap water standard, 7 million fibers per liter that are greater than 10 microns in length. One of the fundamental problems here is that a lot of drinking water pipes are made out of asbestos cement pipes, and that stuff can break off and get into your drinking water. And the monitoring for it and the regulations for it are pretty weak. So in a lot of communities, there may be significant exposure to asbestos through drinking water, and it's not something that I know of anybody that's really looking at. CERCLA, the Superfund law. Asbestos was listed as a hazardous substance, and it can be addressed under removal or remediation under the Superfund law. EPA did update its framework for evaluating whether to clean up under Superfund law. Some sites have been cleaned up or are planned for cleanup under Superfund, but these tend to be the industrial sites that have really severe asbestos contamination, and it hasn't been, frankly, a huge success so far. So Toxic Substances Control Act, as I mentioned, the 1989 ban on asbestos was overturned, but the agency did issue a worker protection rule. Basically, it just expanded the OSHA rules, which I think you've heard are pretty weak and not very well enforced, just expanded those to state and local government employees. The Lautenberg Act, which I know Bob Sussman's going to go into much more detail on, it strengthened TSCA somewhat. The problem obviously has been that there are a lot of shortcomings in the implementation, and there's some limitations in the law itself. The agency has issued a couple of rules. One was on discontinued uses. I'm assuming Bob is going to talk about that perhaps a little bit. And then there's a reporting and record-keeping rule, which is very limited, but requires some reporting by recent manufacturers and importers and processors of asbestos. This one I know Bob's talking about, so I'm not going to spend a lot of time on, but there was a Part 1 asbestos rule that was very limited just to one form of asbestos, chrysotile, and also applies to just import of asbestos for chlor-alkali facilities, which is one of the major ongoing uses of asbestos in industry right now. It's phasing out those facilities in the coming years. And then the Part 2 asbestos risk evaluation, which Bob is going to talk about, reviews some of the legacy uses, and obviously Bob will discuss some of the litigation that was necessary to bring some of these actions. Other federal agencies also have some degree of regulatory requirements. OSHA in particular has these three standards that I just am going to highlight. One is the Asbestos General Standard for permissible exposure limits and some engineering controls. Asbestos Construction Standard, again, this, I think if you go to construction sites where there is demolition going on, how many of the workers are complying with the asbestos construction and demolition standards? I think it's very unusual that there is compliance. Same thing with shipbuilding, including demolition, salvage, and repair of ships. And then, obviously, some of the shortcomings in the rules are significant, and then there's real compliance issues. Other federal agency rules include Consumer Product Safety Commission rules. They're very limited for emberizing materials, those things in a fake fireplace, patching compounds, and some garments with asbestos. I love these slippers made out of asbestos. Those, in theory, would not be allowed anymore under CPSC rules. Mine Safety and Health Administration, in theory, some limitations for surface and underground mines with asbestos, although, as we all know, I think most of the asbestos mining is overseas. Basic conclusion is that there are very limited and often weak EPA and other agency rules regarding asbestos. There are huge gaps in protections, and really the only solution here is a nationwide ban enacted along the lines of the RBAN Act. Thank you.
You have a few minutes left.
I do.
Could you add just a bit about the Chevron deference opinion, because that was an NRDC case?
It was.
Okay.
Yeah, so Linda asked me about the Chevron deference opinion. There's a case called Loper-Bright that was recently decided by the U.S. Supreme Court. It's one of these decisions that the three new justices were basically the driving force, in particular Justice Gorsuch, whose mother was the EPA administrator back in the day when I worked for EPA, believe it or not, under President Reagan. And that decision, basically, there has been a long-standing multi-decade decision called Chevron versus NRDC, my organization, that basically said that the courts will give deference to the expert agency's interpretation of a statute. That decision has driven a lot of district court and Court of Appeals and subsequent Supreme Court decisions for the last 40 plus years that, like EPA, gets deference when they interpret their statute. This decision that was recently handed down, the Loper-Bright decision and another decision, basically threw that out the window, reversed the decision, the Chevron decision, and basically says that the courts can make their own mind up without having to give any deference to EPA or other federal agencies that are experts in the field. And the fundamental issue now is that whenever EPA issues a rule, they are going to be subject basically to de novo review of their interpretation of the law. And that will make it easier for industry potentially to sue and overturn EPA rules on asbestos and anything else. The flip side is that a group like NRDC, if a bad administration starts making bad decisions, NRDC would also, and other plaintiffs, other petitioners, other public interest groups will be able to sue over those and get them overturned. So that may be sort of an unforeseen consequence for industry, that we and some of our colleagues may be able to get bad decisions by agencies overturned. So we'll see. I mean, I think the industry has been driving for this for so long because they have, bottomless pits of resources to try to overturn EPA and OSHA and other rules, and we fully expect them to take maximum advantage of this decision and to try to overturn EPA and other agency rules. So we'll see how that works out. We haven't seen a lot of new cases yet because it's a fairly new decision, but stay tuned.
So you guys can follow NRDC and thank NRDC for their excellent practices, because they do a lot. Thank you, Eric.
I'm Bob Sussman, and for the last 5 or 6 years, I've had the privilege of being ADAO's counsel, which is an activity that has kept me extremely busy, almost nonstop, and continues to create a lot of work. So I'm late in my career, although it's not over, and I've done quite a bit in the course of my professional life. A lot of my years were spent in private practice representing industry. I was the head of the environmental practice at Latham & Watkins for a number of years. I also had 2 stints at US EPA. I was the number 2 person at the agency during the Clinton administration, and then went back under President Obama to be the policy counsel to Administrator Lisa Jackson, and I was at EPA for approximately 5 years. And since I left EPA, I've returned to the practice of law as a sole practitioner, and my practice has been closely linked to the Toxic Substances Control Act and other environmental laws, and my clients have basically been nonprofit advocacy organizations, work closely with NRDC and many other groups, big and small. So I think I'm doing some penance for my years representing big bad industry. So I wanted to pick up where Eric left off and talk about the world of asbestos, primarily at EPA, since 2016. And this has been a busy period. Asbestos has been front and center, I think, in a way that we haven't really seen since the 1980s, when there was a surge of regulatory activity. And the big things that are going on, have been going on, include asbestos ban legislation, which has been on the front burner for many years and is still on the front burner. EPA's risk evaluation and risk management work under TSCA on asbestos, the focus on the legacy risks of asbestos, asbestos mandatory reporting, which Eric mentioned, and finally, court cases, from our perspective, to force EPA to do its job and get EPA to step up, from industry's perspective, to try to constrain EPA and slow EPA down. So ADAO has been central to all of this activity and has spearheaded public health and legal advocacy with EPA. And I think it's fair to say that we've won some important battles, but the war is certainly not over. And we have much more to do. I just wanted to give you a rundown of the various activities that EPA has initiated since 2016. And 2016 is important, of course, because that's when Congress amended TSCA through the Lautenberg Act. And a central issue in the legislative debate about TSCA amendments was the 1991 court decision that, as Eric said, certainly took the wind out of EPA sails on asbestos and more broadly crippled EPA's chemical risk management program. And throughout the legislative debate, there was a lot of discussion that if TSCA doesn't give EPA authority to ban asbestos, then it's a broken law, needs to be fixed. And so asbestos was the poster child for the shortcomings and deficiencies of the law. And indeed, when he signed the Lautenberg Act, President Obama referred to asbestos and said, if we can't ban asbestos, we're not doing our job, and that's why we need to fix the law. So, with that as the backdrop, EPA's been under a lot of pressure under TSCA to address asbestos, and here briefly are the things that EPA has done chronologically. In 2016, it prioritized asbestos for the first set of risk evaluations under TSCA. In 2020, it completed its Part 1 chrysotile asbestos risk evaluation. In 2021, it initiated its Part 2 evaluation to address legacy asbestos exposure. In 2022, EPA proposed its Part 1 rule building on the chrysotile risk assessment to regulate 6 chrysotile conditions of use. Then in 2023, EPA finalized its TSCA reporting rule, something that should have been done years earlier, and that rule required industry to report on its activities under TSCA. And then in 2024, EPA issued its draft risk evaluation, and also in 2024, it finalized the chrysotile Part 1 risk management rule. Even though EPA has been busy on asbestos, the results have been, from our perspective, pretty disappointing and inadequate. And I've listed here the things that we think have not fulfilled their potential that EPA has done. And that certainly includes EPA's work on the Part 1 risk evaluation, which EPA's Chemical Advisory Committee lambasted as being deficient and inadequate. And it also involves EPA's unwillingness to address legacy asbestos, which in the end required 2 sets of litigation before EPA would actually commit to doing a legacy risk assessment. So as we look forward, the jury is out in a couple of critical areas. The first is how well will the Part 1 rule stand up to judicial review in the Fifth Circuit? Will EPA effectively evaluate and address the risks of legacy asbestos? And importantly, how will EPA use the information that it gets from the asbestos reporting rule? Our role has been to hold EPA accountable in the courts and in the policy arena. We helped to mount the successful legal action holding that EPA must address legacy asbestos use risks under TSCA. We obtained a court decision which mandated that EPA undertake reporting under TSCA on current asbestos products and exposure. We filed a petition for review of the EPA Part 1 risk evaluation and settled that case. We also filed a suit against EPA to compel the court to set a deadline for initiating and completing the Part 2 legacy risk evaluation. And as a result of that suit, EPA has an enforceable deadline of December 1, 2024 to issue a final legacy evaluation. I wanted to briefly identify the flaws with the Part 1 rule. These are some of the issues that we may see in the litigation, although, as I think Linda mentioned, the litigation was initially brought by industry, and industry has a number of concerns about the rule, which they will undoubtedly put before the court. But from our perspective, we think that the rule rewards Occidental Chemical and the American Chemistry Council with a 12-year phase out of asbestos in the chloralkali industry, which we really think is unnecessarily long and will have the effect of prolonging exposure to asbestos, use of asbestos, disposal of asbestos in that industry. We are also very concerned that this rule is what I would call a mini ban. In fact, it only addresses 6 chrysotile conditions of use, and it ignores the other asbestos fibers entirely. And so I think what we're left here is controls on a small number of existing asbestos uses, but the door remains wide open to other issues of chrysotile or perhaps other uses of the 5 other fibers. The rule does not meaningfully address air, wastewater, and disposal risks, which we think is a clear violation of TSCA's mandate. And it also fails to address the ongoing risks of asbestos in gaskets that are found in several industrial sectors and in brakes and other asbestos products in vehicles. So EPA did face intense industry opposition, which was spearheaded by ACC and the U.S. Chamber of Commerce. They questioned EPA science and worker exposure limits. They claimed that the rule threatened the availability of chlorine and caustic soda for drinking water treatment. And in the end, I think that the pressure applied by industry had its effect on EPA, and EPA did accommodate industry on a number of important issues. If the Part 1 rule is remanded or vacated, it may be in limbo for several years. And so I think that forces us to once again focus on what legislation has to offer. And it offers quite a bit: no litigation, long-term certainty, hopefully an expedited chloralkali phase out, an immediate end to asbestos imports, a ban of all 6 asbestos fibers in all present and future conditions of use. And it also enables EPA to devote resources to Part 2. So legislation will lock in a comprehensive asbestos ban, whereas right now the outlook for EPA regulation enacting a comprehensive ban is pretty uncertain. So I'm going to stop there.
Great presentation, then there'll be more to come.
Okay.
So next, we have Rebel with a Cause. Dr. Castleman, can you please come forward? So Barry is beyond an expert. His knowledge is deep. He is such a wonderful human. When it comes to asbestos advocacy, Barry is so genuine and committed. You are astounding, and it's an honor to call you my friend, and I know I can always count on you. So you're going to hear Barry talk about how the evidence is used possibly in the law, I suspect. And Barry, welcome to the podium.
Thanks.
Yeah, love you.
I'm going to try to talk about kind of the big picture of public health struggle over asbestos. Looking back since I first got involved in this, I started reading about the hazards of asbestos in 1970. I was being trained in air pollution control. That was at a time when the United States government was more functional. They had created fellowships to train people in air pollution control even before they created the Environmental Protection Agency. And so I started reading about the health effects of pollutants because I was just an engineer, didn't know anything about public health. And when I came across asbestos, I was just dumbfounded because I soon found the Selikoff proceedings from the 1964 conference and documenting the appalling risks associated with it, even to members of the households of the workers and the neighbors of the asbestos air pollution point sources getting mesothelioma. So this meant that millions of workers were at risk, and their family members and all the people that lived around all these shipyards and construction sites. It was most of the population was at risk of getting this dreadful, these dreadful cancers. And but still, the use of asbestos kept going up. In 1970, I found it had kept going up after this conference had been held. And this was because there was no regulation. There was little in the way of information. Dr. Selikoff was doing a heroic job of reaching out to the media in a way that practically no one else could. He had a kind of a fluency, a way of answering questions. Journalists would say things like, well, the asbestos industry says this is a big emotional thing, this thing about asbestos. And Selikoff leaned back and said, well, most forms of cancer we don't know how to prevent, but there are some that we do. And I get emotional about cancer that could be prevented that doesn't get prevented. That was his way of, he always had a great answer for the media. And none of this I'll get back to you tomorrow stuff. Anyway, with Selikoff and environmental groups like the Natural Resources Defense Council, things got turned around finally in 1973. The use of asbestos in the U.S. peaked and started going down. And so we were starting to make some progress. It went down by half from 1973 till the end of the 1970s, and then plunged after that. Meanwhile, personal injury litigation in the United States rose from hundreds of cases to thousands in the late 1970s, and through the power of legal discovery, lawyers representing asbestos victims laid bare a history of toxic corporate crime, there for all to see in the words of the perpetrators. And the liability thus established ended the use of asbestos in the United States, despite the courts overturning the EPA ban. It really was the only country in the world where liability got rid of the entire use of asbestos in production of products in the country. In the rest of the world, the costs of asbestos have been borne almost entirely by the victims and the National Health Services. without any disclosure of how big companies made fortunes selling asbestos. The companies walked away practically without any liability for the cover-up, without responsibility for the sale of products that are still killing people every day and still endangering millions of people's lives. The European companies avoided having their managers and doctors have to testify about what they knew and did, and they avoided revealing damning documents about how they sold asbestos and covered up what they did. Sometimes the evidence unearthed in discovery here is enough to support cases against employers. Workers' compensation laws passed in the, between 1910 and 1920 were passed for the purpose of limiting, of preventing workers from suing their employers for getting occupational injuries and disease. And that was the whole, and all of these workers' comp laws were supported by business interests and conservative governments. But in Pennsylvania, plaintiffs' lawyers were able to convince the courts that because of the short statute of limitations in the workers' compensation law, the workers' compensation law doesn't apply to asbestos-related disease, and so employees have been able to sue employers in Pennsylvania in the last few years for asbestos conditions. There are other cases where the workers' compensation law can be pushed aside as a limit if the liability evidence against the company is so damning that the court allows that the worker can sue the employer. And this has happened in the case of Alcoa in Missouri and Rogers Corporation in Connecticut, where the courts presented with the evidence of the horrible conditions in the plant documented in the corporate documents have said, yes, you can take this to a jury without the limits of a workers' compensation law in terms of recovery. Decades of litigation and discovery of corporate documents have unearthed a veritable encyclopedia of toxic corporate crime. Hundreds of companies have been subject to legal discovery over the last 40 years. And the kinds of things that have come up have included suppression of medical and experimental findings, statements by industry trade associations that asbestos products are not toxic, prolonged violation of regulations requiring warning labels on asbestos products. So there were two periods. There was before government regulation and then after the 1970s with government regulation starting to happen. And so the corporate documents show the cover-up in the beginning and then the reaction when they were on the back foot, fighting regulation and newspaper inquiries and things like that, and workers and unions raising protests. Other examples of things that were shown in the corporate documents were suppression of positive medical findings when they chest x-rayed their workers and didn't tell them they had asbestosis. Some of these companies firing workers and busting unions for protesting asbestos hazards. That was Westinghouse, for one. Exporting banned asbestos products, labeling asbestos-containing products asbestos-free, subcontracting hazardous asbestos work by major corporations. Alcoa and Reynolds Aluminum come to mind, and Westinghouse. And just the total failure to have any sanitary precautions to keep workers from walking home with the dust on their clothes and endangering their families. This is one of the most extreme crimes of industry, and not just provide them with some showers and separate lockers. You don't even have to tell them this stuff can kill them. Just say, clean up on your way home. We'll provide you with the work clothes and wash them here at the plant. You don't have to take that home. Renowned New Yorker journalist Paul Brodeur called it a 50-year history of corporate malfeasance and inhumanity to man unparalleled in the annals of the private enterprise system. This was his conclusion in his third book on asbestos, Outrageous Misconduct, the Asbestos Industry on Trial. As a public health scientist in the 1970s, working with environmental groups, I encountered some people like the new lobbyist for Johns Manville in 1974. He invited me to an expensive French restaurant across the street from his lobbying office, which I could have never afforded to go to, and spent the entire lunch insulting me, saying that I was just, saying terrible things about the asbestos companies and just trying to give them bad publicity because I hated corporations. Not that there was any problem with asbestos. That same year, Johns Manville hired Paul Coton, the first director of the National Institute for Environmental Health Sciences, as a vice president for health and safety, and they would send him in to oppose asbestos regulations at the EPA and the Consumer Product Safety Commission and OSHA. And Coton would also testify that back in the day, people didn't know asbestos was dangerous, so he was even helping them in damage suits brought by their former employees and workers who used their products. As a local health official in Baltimore in 1972, I sent warnings out to break-in muffler shops and new and used car dealers, warning them not to take compressed air hoses to blow out brake assemblies. This was just before any of the brake manufacturers or auto companies were putting any warning labels, which were by then required by OSHA, on their products. 3 years later, NIOSH issued a detailed warning about the dangers of brake and clutch repair and said there were 900,000 people in the country who were working as mechanics who were at serious risk. And then the EPA published something called the Gold Book, which was a pamphlet for people to understand about the dangers of doing brake repair. About 2 million brake repairs are done by people on their own cars and trucks every year. And then in 2003, a law firm called Morgan Lewis, with undisclosed clients, including General Motors and Chrysler, pressed the EPA to withdraw the Gold Book, claiming that newly published articles by mercenary scientists hired by General Motors, Chrysler, and other companies showed that the asbestos exposure of mechanics wasn't causing asbestos disease after all, and they could withdraw this warning booklet, which was being used in the courts against the same companies. And we had quite a fight on our hands. Richard Lemon published an article detailing many reports of mesotheliomas in mechanics that had been published. Dr. David Eagleman discovered corporate documents showing that the companies were measuring the exposures associated with the brake repair work and acknowledging the dangers in their own internal documents. And with the determination of dedicated public servants in the government, in the EPA and OSHA, EPA and OSHA did reaffirm the hazards of brake repair in documents they published in 2006 and 2007. And it was the brakes were the thing that kept back the idea of banning asbestos. And it was the Swedes that forced Saab, Scania, and Volvo to come up with brakes that didn't include asbestos for new cars and for replacement brakes. And once they were able to do that in Sweden, it soon spread to the rest of Europe. And by the end of the 1990s, bans on asbestos were going on all across. All the major companies in Europe had bans on asbestos in the 1990s. And that forced all the automakers, including the Americans and the Japanese automakers, to make asbestos-free cars so they could sell in the European market. Turning to criminality, criminal prosecution of the Swiss asbestos billionaire Stefan Schmidheiny in Italy was practically unique in holding an asbestos industry executive and owner personally responsible for business decisions that doomed so many people's lives. In between 2018 and 2023, Schmidheiny was tried in 3 courts in Italy and convicted in each one and sentenced to jail time in each of these 3 cases, and they are now working their way up and being appealed by Schmidheiny's lawyers. Schmidheiny is a multi-billionaire asbestos magnate. Criminality on the national scale has been conducted by the Russians. Russian and Kazakh owners sending the spy to spy on asbestos activists in Asia in particular, and us, between 2012 and 2016. Russia has used trade measures to oppose asbestos bans in Thailand. And in Sri Lanka, they claimed that tea that was an important export of Sri Lanka to Russia had insect fragments in it one year when the Sri Lankans were talking about banning asbestos. And those things were connected. Russian asbestos interests bought into companies making asbestos roofing sheets in Vietnam and then formed a trade association to lobby against banning asbestos in Vietnam. This was too much for the Communist Party, which called in the press and said, don't publish anything the trade association says. So we've got 250,000 people dying each year from past and continuing asbestos use in the world. And I just wanted to say that most of this is in Asia. We're still using 1 million, about 1/5 of the total at the world peak in the mid-70s of 5 million tons a year. And the Australian Asbestos and Silica Safety and Eradication Agency, an agency set up under pressure from the Australian unions, has been going around to many of the Asian countries still using asbestos and raising awareness of the local communities and civil society to try and start to bring about public health progress there. I just want to conclude that we need to ban asbestos in the United States. We need to support the Alan Reinstein Ban Asbestos Now Act and get that passed so that we can catch up to Croatia and the other 68 countries that have banned asbestos.
Thank you, Barry. We have time for 2 questions. If anyone has a question, and Emily is going to bring Dr. Frank has one in the back.
Thank you. A very simple question. With the ban on chrysotile with six conditions of use, if a company wanted to continue to use asbestos, could they now turn to the amphibols and start putting that in products?
Well, let me answer that. I think under the Part 1 rule, there's no impediment to importing amphibole or amphibole-containing products, and there's also no impediment to importing chrysotile-containing products for uses beyond the 6 conditions of use addressed in the rule. So from my perspective, the door is wide open now. You can debate whether anybody would want to import an amphibole-containing product into the United States, but you never know what's going to happen down the road, and that's why you need an enforceable ban, because without an enforceable ban, should anybody try to import, there's no basis for stopping them. Now, I will say that EPA issued what they call a significant new use rule, and Eric mentioned this rule, which they say keeps additional products out of the United States. And I think our response to that is it's not an effective rule. It's actually a rule that is legally flawed, and I would not rely on that rule, whatever EPA says, to provide effective protection against importation of additional asbestos products.
Thank you, Bob. 2 points for you to think about. It is, I think, in my humble opinion, I think it's very likely that the Part 1 lawsuit could end up in the Supreme Court because there's so much money fighting it. And as Jackie said in her presentation, if you don't want to find asbestos, not your words, but if you don't want to find asbestos, you can use low-level testing methodology, and gosh, it just might not be there. So we have set it up for industry to double win on this. One last short question.
Sure. So, Barry, I was interested. My question was going to be around individual liability, and you mentioned that one unprecedented case, and I'm wondering, like with laws around cybersecurity, we've seen a lot of more individuals and boards and corporations being held liable. And I'm wondering for the panel, how important do you think it is for teeth with our laws around asbestos for individuals to be held more accountable in these corporations, like this dude, Mr. Oren?
Barry, the question's for you, and that will be the last question.
Yeah, I'll just walk over to you, Mike.
Okay, you come over here.
Well, over the years, I've come up with a formula for prevention. It consists of information, regulation, compensation, humiliation, and incarceration. And I really believe
Say it again. It's so good. Say it again.
information, regulation, compensation, humiliation, and incarceration. And I really believe that the holding corporate executives personally responsible for business decisions that doom other people to die is something that's fundamental, that needs to be a part of the law. It is a part of the law in Italy, and it should have been here. Congressman George Miller tried to introduce such legislation in 1979 based on what was coming out in the asbestos litigation for corporate executives suppressing certain types of information to be held personally responsible. Of course, that never went anywhere in the Congress.
Great panel, and I want you to look at the program. God knows what page number it is. Those are late at night kind of programs I put together. There's a letter from Olin Corporation that supports our ban. That is a pretty unique thing for a small nonprofit to secure, is industry buy-in and approval. So please take note and know that there are some companies, and we'll encourage them all to come to the trough willingly or hogtied. So this is our last panel, and it'll be 20 minutes of a conversation. It was organized and discussed by Perry, Ann, and Greg and I. So it should be information that the average person that might have exposure and or been diagnosed can benefit from their knowledge, the work they do. And to be honest, I want to end the shame of asbestos victims feeling like they shouldn't file a case because they're embarrassed that they've done something wrong. And it can be a very muddy place to be. So you guys introduce yourself, talk amongst yourself, as we say in Hollywood, and then we'll save 10 minutes for Q&A. Does that sound okay?
Sounds perfect.
Perfect. I'll be a good listener.
All right, so I'm just going to give a little format of where we're heading with this, so you have a structure. I mean, you saw the agendas that we've had today. You've talked about medicine, science, legislation, lawsuits, civil lawsuits that individual families have had. And we're going to bring it to the cap at the end about how all of this together makes change. Well, civil litigation or lawsuits has an impact on companies, it has an impact to help families, but it does make a difference. And as Dr. Lemon had mentioned earlier, someone asked him a question about, well, when did this start happening that asbestos started to be used less? It was the lawsuits that pressured these companies to stop. You'll see interrogatories that say, we stopped using asbestos-containing products due to public pressure. That public pressure is through your voices and through the lawsuits. So today we're going to talk a little bit about where we've been with civil lawsuits. We're going to talk about where we're going. And if you saw the complaint that Martin Ditkoff put up there earlier, it was very blurry, but the lawsuit back then, 20 years ago, is very different from what you're seeing today. There's still some of those, but they're also very different. And then we're also going to talk to you. You all know you need a doctor when you're diagnosed with mesothelioma, and you go get the best treatment you can with physicians that we have here. But many people don't know that while they need a doctor, they also need a lawyer. They need a law firm. They need people behind them that are going to fight for them. And if you didn't get the message with what Barry, Dr. Castleman, was talking about fighting, why people should be angry, why people need to step up. You heard all those things that he was saying about how they've lied, how they've manipulated data, how they buried information, how they exposed workers, and the epidemic they've caused of mesothelioma and other asbestos-related deaths. That's where you know we need to step up. So Ann, take it from here on where we've been. Wherever you want to be.
Yeah, the sound will be better. I just put a generic 20 minutes. You guys share it.
Thank you, Perry, and look forward to this. So a little bit about where we've been, and I'm not going to go through all the legal cases that we have because that'd be like in a law school class, and I think this is what more of this is like what's really been going on. And I'm going to speak a little bit from the trenches. When I joined Motley Rice and its predecessors back 40 years ago, I was a paralegal, and I should start off with I'm from a law firm in South Carolina. I've been there 40 years. Motley Rice, we've grown and changed different law firms over the years, but the one thing we've done since the early 70s is fight the asbestos industry and represent asbestos victims. 7 offices in different states, and I have some of my colleagues with me today. But a little bit of today, a lot of today, all of today has really been a memory lane. And when we talk about where we've been, you've just heard it. I mean, everyone in this room has been a part of where we've been, and everyone in this room is about where we're going as well. But when I started, I love seeing some of the pictures, and it worked with Dr. Anderson and Dick Lemon and Barry Castleman and Arthur Frank and Dr. Molina. I haven't had the pleasure yet, but my colleagues have with you as well. But we were looking at the ceilings and the exposures, and we looked at where things came from. I was what I called a product ID investigator. And every one of our firms probably has them now. But what's so important in this litigation is whose tiles or what was above the tiles, whose spray was on the ceilings, whose decorative things were on there, what was in the boiler room. And I started when I came down in 1984 working with the school district. So I always say before I represented victims of asbestos and sick people, I represented sick buildings to get the asbestos out of the buildings. And when I came down, I had a team and investigators, and our job was just like, you need to figure out who's asbestos up there. We sued a bunch of companies, so we knew it was going to be National Gypsum, W.R. Grace, USG, something of that nature. But we had to really go and work with the trades, work with plasterers, work with scientists, material scientists. We'd fly around and, at midnight sometimes to school buildings because we couldn't do it during the day, had everything, done so we wouldn't cause any exposures, but get up there with microscopists and scientists there to, take samples from those ceilings, look what it is. And also, go into warehouses or barns or basements and looking for old invoices. So when part of what we're talking about is the legal profession, I always say make sure your lawyers and their staff are willing to get dirty. And I mean dirty in a way of dig and not give up when we need to find what we need to do with that. But we also had to learn about the fiber release, and we talked about that today too. It's encapsulated. Oh, it never comes out of those products. It can't get into your breathing zone of that. So the litigation as it progressed, the new technology that would come around with the microscopes and things, you couldn't see it with the naked eye. We did that experiment of showing you can't see it. So when teachers or people were playing or in the boiler rooms or even working in various trades, if you didn't have that dusty insulation, which even then, the workers may not know there was asbestos in there, you needed to have the scientists to work through it as well. I was blessed as I went through my early career as being the investigator and the one out there in the fields and Department of Labors and digging up a lot of the documents with Barry Castleman mentioned. I spent years in Library of Congress looking both for historical knowledge documents, but also the historical documents of, well, whose products were out there. And when we talked about all the different things that Dr. Anderson talked about, the mines and the plants and the households and, whose were they? Because the only way we could seek compensation and justice for victims was to have the defendants who were the culpable defendants identified. And I'll talk just briefly about what our ultimate responsibilities are. But it's fair to say as lawyers, we spend time educating, we help legislate, but this is about our role in the litigation on that. I was blessed to have worked also in the 1970s with Ron Motley, who was one of the pioneers, as several other lawyers were, in asbestos litigation. And after about 10 years of married, having kids, and putting off law school, my mentor put me through law school. So I could not now just advocate and look for the documents. I could actually speak in the courtroom and advocate on behalf of victims. And part of our litigation of what we have to do, and if we were teaching a law school class, we'd have to say we have to prove a duty, that the company had a duty, that they breached that duty to the victim, We have to prove that causation, and we have to prove damages. And those are things we'll talk about a little bit more, but the breach of that duty is, did the conduct cause the injury to the person who is bringing the lawsuit on that as well? And then the damages, we talked about that today. We've got to get through those three things. And then the most important thing of this is the story and the damages. And it's not just financial compensation. It's the ability to get your story out there and get compensation for the distress and mental anguish you had on there. When we talked about duty and we talked about the early cases and that we've talked about today, when the earliest cases came out, my partners tried some of those cases and they lost. And that was in the early 70s. Because it wasn't until the mid-70s some of the documents were coming to light. You know, we lost the first cases because they said, well, they didn't know. These companies didn't know anything. And as Barry just indicated, they weren't too forthcoming in saying, oh, yeah, we knew, we just didn't want to tell you and things. So, well, the lawsuits that we lost in the beginning started producing documents. When we'd go back and say, well, you know, we maybe didn't have everything that you had in your files there. Some of the earliest documents in 1976 come from the plants in South Carolina that we started our litigations. And I always love to quote one of the first ones from the Sumner-Simpson papers, we call them. They weren't available at the first years of litigation, or the early, at least, cases of litigation. But you had the Ray Bestis Manhattan Plan, and the Sumner-Simpson of Ray Bestis to Vanderbilt Brown of Johns Manville, 1935. I think the less said about asbestos, the better off we are. Johns Manville, Vanderbilt Brown replies, I quite agree with you that our interests are best served by having asbestos receive minimum publicity. And for that, and for many other companies who followed, put us in the position where we are in today, where we have that exposure pyramid of asbestos being in the factories and the product users and the bystanders and the housewives who were exposed by the very dust and the children bringing home. For the fact that it wasn't made public, and it was when it started becoming public, there was always something that they could explain away why they shouldn't be liable for a product on that. We couldn't do this litigation without the professionals we've heard throughout the day today. I think when you talk about law firms who take these cases, you've got to know about epidemiology and occupational disease and the public health aspects of all of these things with this too, and microscopy, industrial hygiene, and historian. There's so much at play with this, and we couldn't do it with the work with that. We have to fight the defenses. And again, Barry kind of touched on this a little bit. First, it says, well, asbestos doesn't cause disease. And then it was, well, our asbestos doesn't cause disease. Well, if it's our asbestos that caused disease, if it can cause disease, you weren't exposed to our asbestos. And well, if you were exposed to our asbestos, it wasn't enough and someone else is responsible. So every day we're in court, we're working through those defenses on there and working to say, well, at the end of the day, someone's responsible, and usually we have those folks in the courtroom on that. When I describe what I do for a living to people who maybe haven't been around and looked at this, but it's simple, and it's simple for a number of people in this room. We sue for safety. We help victims tell their story. We help hold corporations accountable. Best way to hold corporations accountable is to shine light into their files, into their documents, into their testimony. You can't do that without a lawsuit. Sometimes you can get a subpoena power to get those, but most of the documents that come to light that have been so damning on the industry, and there's still documents found in so many litigations that are new, which is quite amazing. But shining a light, is what we find some of the documents. And the knowledge that is out there and probably really prevented science even earlier to come about with those. But we're helping the individuals and the companies are responsible, and at the end of the day, to prevent this from happening. And I wrote down the quote that you said about your father because it's so impactful. Don't let this happen to other families. It just isn't right, and it can be prevented. And that's our role in the lawsuits. We can't prevent it, what happened to the family. We can't prevent it to the exposures that have occurred and the diseases that will happen, but we can tell a story of what the disaster this is called, and even for other industries that you can't have this again. So when I tell clients when they walk through the door, And what they usually want is they want to tell a story. And we're going to hear more about how you can tell your story. You want to seek justice. You want to hold the companies responsible. You want to ask, how did this happen? And you want to find comfort in knowing that you're working with a firm or whoever you're working with within their firm has worked with asbestos victims and stand on the shoulders of the work that has been done to others on there. I know we are honored, and for my firm of representing victims and their families, and I can speak for each one of my staff, attorneys, paralegals, investigators, that your stories become their stories, and they gain strength, and I can personally attest to this. When we represent victims of asbestos exposure, the courage that you've put forth to even be brave to bring a lawsuit and to go through the things that Perry and Greg are going to talk about there, it's not easy, but it's just, and it gets your story out, and it's justice for your loved ones. And we're very, very honored when we do represent your families.
Thank you, Ann.
I don't have a lot to add.
You're going to tell us how we do that.
Just so you, that we're there. Yeah, left.
Yeah. So I don't have a lot to add. We just learned a lot, but we understand that when we come into the life of someone who's diagnosed with mesothelioma, it is a life-changing, to say the least, moment. And we want them to focus on their medical. So our job is, as has been stated, to put that puzzle of exposure together. We know it's a unique diagnosis and that it is only caused by asbestos exposure. And our job from the moment we start, from the moment we meet the client, is to put that puzzle together through every potential avenue of exposure. And that's what we do. That's really all I have. I think we want to answer some questions if you have any questions.
5 more minutes. That's okay, then we're going to have 2 minutes.
Just going to add a little bit in there.
Cool. Thank you, Greg. Come on, Perry.
Greg, Ann, and I have seen some interesting things. And Dr. Moline was talking about that earlier. When you talk about whether it's an occupational history or an exposure history, it's that puzzle you're talking about. Because if you ask most people, you ever exposed to asbestos? No. You ever talc? No. Okay, we're done. Well, it's not that simple. We're now finding these exposures are all so different. Greg's firm represented a lady that had no known exposures, except she was a professional baton twirler. Flaming baton twirler from little kid up to through college, right? A flaming baton that had chrysolite paper on there that she twirled, exposing herself to amphiboles and being poisoned while she was doing it. You don't think of that. We have people that are scientists. They were always in college. They had their biology class, their chemistry class. And what are they handling? Asbestos tongs, asbestos pads, raw asbestos in little bottles for experiments. You wouldn't think that would be enough, and it does. It causes meso. Printers that work on printing presses, they're running millions of pieces of paper through their entire life, being exposed to asbestos in those machines. Do you think of that as an asbestos worker? No. We think of the pictures of Texas with miles and mountains of pipe covering. So it's our job to work with you, to listen to you, to find out what Mr. Duran went through. What did he use? Where was he exposed? And by listening and working with the family, we then come out and ask for your help. We come to the experts and say, we have this individual. This was their exposure. We need some help. We turn to Barry Castleman and say, what documents do you have? We talk to Dr. Lemon about what were the regulations. We talk to Dr. Frank. Well, is this enough exposure? Can you review this exposure history? We asked Dr. Moline to show up at court and Dr. Markowitz to show up at court and all of our other experts to step up and fight. And the important thing for all of you to know is there's a team behind you. You're not in this fight by yourself. Your voice is being heard not only at that deposition, but in that courtroom, and in Washington, D.C., and as Harmender was telling us, around the world. That Cape lawsuit in South Carolina right now is opening up new avenues of recovery for people. And the odd part about it is the other defendants are happy it's happening. They're looking forward to blame somebody else. They're looking forward to somebody else to pay part of this, load. So what we're trying to say, and we don't want this to be a message just for our firms, is if you know someone with mesothelioma or someone that is sick, tell them, get a good doctor, and tell them it's okay, get a good law firm. Because behind the law firm are many voices like Linda and ADAO, experts, activists, photographers that are here to help everybody and to fight for this. And what we want to do is help make that a little more comfortable. We're going to be there for you in a non-intrusive way because we're there to help you, help the family, let the family know their security, and that your loved one, when they are ready to pass away, know that everything's going to be okay for the family. I had a client that said, Perry, do you think I can get that roof on the house before I pass away? I'm like, roof? He's like, I've been promising to get that roof fixed for 10 years and I haven't done it. Little thing like that, we got him recovery. He put the roof on. He says, thank you. That's just a roof. But he was so worried about making sure he finally got that done while he's on oxygen, on opioids, and all this, and going through depositions, wanting to know that that can happen. So we're here today to answer any questions you have, but we're also here today to encourage you to encourage others. Get a good doctor, and don't be afraid to hire a good law firm. If you don't hire ours, call Ann's or call the Gorey firm, and you'll be in good hands.
Thank you.
And also Early is a good sponsor too. They do excellent work.
That was excellent. And just so you know, ADAO does not make any legal referrals. I think you heard from Perry. They're not in it to pull in all the chips off the casino tables. They really want to do the right thing for the clients and move forward for justice. And your discovery helps me with policy because I can dig deep and get materials and evidence that I need. Let's open it up to questions. I will ask you guys to be brief. We have 5 minutes-ish for questions. Do we have any? Emily, set to go. Bob.
I'm wondering how you would describe the role of punitive damages in the asbestos story. Has it been important from the standpoint of settlement? Has it been important from the standpoint of changing corporate behavior? Have there been significant punitive damage awards?
I would answer yes. And punitive, it's really when we talk about compensation and accountability, that does go to that second part of accountability. It's seeking justice for the family, but also sending a message to other companies. But so, yeah, there's been a number of punitive damages awards. And basically, at the end of a trial, either during the trial or right after it, it could be a separate phase, but the jury will be asked, should we award punitive conduct? Did the conduct rise to a certain level to say, okay, you've taken care of the compensation for the plaintiff, you've dealt with the mental anguish, did the company do something so bad that they should be penalized? And it's often done either just by $2 million, $5 million, $200 million, or in some trials I've been involved in when they're consolidated trials, it'll be for every verdict that comes in, it's a 3 times more multiplier. So short answer is punitive damage is very important. The court has to allow us to go through it. Does it send a message eventually? I mean, the whole thing is supposed to hit them in the pocketbook where it hurts. So that's why you have the punitive damages there. I hope some of the CEOs pay attention to it. Can't guarantee it if they can pay for it, but I think it reads loud and clear when it's in the newspapers on that and does send a message. Perry, you may have.
Well, and a great example of an unnamed baby powder company that was getting nailed with punitive damages, they went to a non-asbestos non-asbestos talc in their baby powder. It's now cornstarch. First it was in the United States, and they were still going to sell it overseas. And then, well, public pressure and all the activism got them to it. But those punitive damage awards, that was a current modern day existence, not something going back from use that was done in 76. So it absolutely has an impact.
And that's why the documents are important, to find those documents, see what they were hiding, see what they're doing. And, you know, people get really mad on that.
Advocacy in the law was seen very well, I think, with Johnson & Johnson, where us as women, women of minority, we fought hard. We raised a lot of stink, and ultimately we were able to get Johnson & Johnson to pull the baby powder out of international markets. They pulled out of the U.S., but then they were still peddling that junk. And I think it shows how your evidence allows us to do more effective advocacy. We have time for one more question. Yes, Nicole.
Yes, thanks. My question is on proprietary agreements, like, you know, in products and consumer products. How much are they able to actually hide in that? And what is your, how do you take on that if you are going to take on a case and they've hidden it in their, you know, in there somewhere?
I was going to say, you can bury it as much as you want. Eventually, the truth's going to come out. You can put it in proprietary documents, confidential documents, but these things do get out there. I mean, Barry's been the master of finding documents that go back, way back when, and there's been court orders opening that up. Some of the harder ones are when, you know, it's covered by federal contractor defenses, where it's current, you know, military secrets. And in those circumstances, the courts may order that they disclose it, but they have to be kept confidential, and they're only used in that specific trial. And that's hard because eventually that may go public if you're going to be trying it. So they can bury it, but it's not an effective way. It's going to come out.
And I think it only comes into play maybe when they call it a trade secret or something with that too. And that's usually for something that's still on the market. So it would involve some products out there. For products that are no longer on the market, they need to, you know, if there's an interrogator who says, how much asbestos do you have in your product? You need to say how much asbestos was in your product. And then some states, it's maybe state to state, but the sunshine laws that they have, if it's a public health issue and something that should be closed to the public health, you can't hide around the fact that, well, I don't want to tell anybody that asbestos is in my product. So there's all different disclosure things there as well on that too. But a lot of other industries have trade secrets on that, but I don't see that in asbestos. They're usually compelled to have to provide the information.
Well, and also what Bob was talking about earlier, you know, these regulations that require disclosure of what's out there, what's in place, what's being used. That's where, again, the legislation and the lawsuits come in.
And we're not going to let them claim CBI on Part 1 and asbestos reporting rule. We are going to dog them to tell us the truth at all lengths, right, Bob? Okay, we have one video from Barry Robson. He is in Australia. It's quick.
Well, hello from Australia, and I hope you've all got something out of the 2 days at this conference. A bit of a milestone conference too. It's the 20th, and the organisation has come a long way since then. And I'm proud to say that the Asbestos Diseases Foundation of Australia was there at the very, very first one. So you've come a long way, small baby steps into getting the ban in place. But the fight still goes on. Don't give up. Don't give up. Keep the pressure on getting that ban in place. It took us 10 long years to get the ban. And then there was a lead-in time of another 10 years. But it's in place here in Australia. And even though it's been here for, since 2003, we are still constantly finding asbestos being imported into our country. So the fight will go on once you succeed in getting the ban in place. To Linda, to Richard, who I've become very fond of, over these past 20 years. And it's just a bit sad that we couldn't be there with you for this particular conference. But the cost of airfares these days and the cost of campaigning just prohibited us being with you in Washington this time around. But as I said, I want to really, really thank Linda for her constant campaigning, never giving up, and still, even after 20 years, you're still there fighting to get this ban in place. So I've got a feeling, you know, with the elections coming up in your country, in America, that hopefully there'll be the Democrats will get control of both houses and the presidency, and I think that might make it easier to get your ban in place, Linda. I hope so. I really hope so. So to all of the friends that I've made at ADAO, Maryland especially, you know, I still get a smile when I think of drop bears. Every time I hear the term drop bears, I think of Maryland and your family. Also, Tony Rich, your photos, everyone that you put up on Facebook, I also share around the asbestos network here in Australia. So, Linda, once again, I just can't say how proud I am of the work that you've done. And your sidekick, Richard, who, you know, works quietly away in the background, you know, champion bloke. Okay, so enough of me and that, because I know it's time that you all want to go home and catch up with your family. So once again, to ADAO, great congratulations for 20 years of campaigning. And let's move on, hopefully not for the next 20, but let's hope that this year or early next year, you get your ban in place. So all the very, very best from me and the Asbestos Diseases Foundation of Australia. Goodbye.